Hello, Bruce.
Hello.
Hello, welcome. Welcome, welcome. Thank you so much for joining. We're so glad to have you.
My pleasure. Happy to be here.
First, we will just have Cheryl, our vice chair, introduce you. But by way of introduction, I am Victoria Williams. I am chair of the State Public Affairs Committee. We represent the 8 junior leagues of New Jersey, spanning from the north of Bergen County to the south of Monmouth. And we have members joining us, from each of our leagues. A few people are missing, but they're on the way. And so, what we do at the Junior League, more broadly, is that we are focused on advancing women's leadership through collaboration, training, and service. And so that's the mission of the league. And as the State Public Affairs Committee, we're the legislative arm of the Junior League, and we work with legislators and advocacy groups to advance initiatives that support women and children. And so we have you here because we're learning about civics and certainly your message tonight, your remarks will be around constitutional literacy, but it's to prepare us to ensure that we know the law and that as we're working with legislators and we're working to advocate for women and children and families, that we're well equipped with how to best do that in the context of the law. So that's a bit about us. And I'll turn it over to Cheryl Bear, who's our vice chair, to introduce you.
Hi. So sorry to make you put you on the spot, but so we have a very accomplished. We have the Dr. Bruce Peabody, so the professor of government and politics at the Department of Social Sciences and History. He's the co-director of the Pre-Law and Legal Studies and the director of the Forum Institute for Lifelong Learning. Professor Peabody is an editor and contributor to 5 books, including Short Stories and Political Philosophy, Power, Prose, and Persuasion, The Politics of Judicial Independence, Courts, Politics, and the Public, and Where Have All the Heroes Gone? Changing Conceptions of American Valor. He has published dozens of scholarly articles and book chapters, short articles, academic reviews, book reviews, and publications written for a general audience. His work has been cited by or appeared in the Washington Post, the New York Times, the Wall Street Journal, USA Today, and many other general audience venues. In 2016, Professor Peabody received the Outstanding Faculty Member Award from the FDU Student Government Association, an award he also won in 2012 and 2004. In 2012, Peabody received the Distinguished Faculty Award for Research and Scholarship from FDU, and in 2004, he received the Becton College Teacher of the Year Award from his faculty peers. Before joining Fairleigh Dickinson University in 2000, Professor Peabody served as an arms control lobbyist in Washington, D.C. And if you'd like to learn more, you can go to his website. So thank you so much. We are honored to have you here. I'm so glad that you were able to make the time to be with us.
I'm thrilled to be here. So I know it can be a little mind-numbing, but I'm going to share a PowerPoint if that's okay.
Yeah.
And I think it'll have some useful backdrops and information for you all. So let's see if I can do this successfully. So in theory, you should see just my notes on the screen. Does that just the images and not my notes? I have notes like take out the dog. Do you see my? Actually, I think I have to start from the beginning. That'll get us going here. That should be it. Okay, so is that what you see there's just the image of the slide right now? Okay, great. So
That's
I'm
perfect.
so grateful to be here. I will talk for maybe half an hour or a little longer just because an academic and a audience is a dangerous combination. Don't but in any event, if you have questions along the way, it's a small group. I am happy to answer questions along the way. Maybe that's not what the local norms are, but you can certainly put questions in the chat, and we'll have certainly time for some, I hope, robust conversation at the end. But I have really tried to take what I understand to be your mission to heart in kind of crafting these remarks and thinking about what to share with you. So before I go ahead, you can hear me okay, see everything, we're good to go.
Yeah, good to go. You're perfect.
Excellent news. Okay, great. So I'm really happy to be here. Thank you, Cheryl and Victoria, for inviting me, and all of you for making the time to share what thoughts I can with you, and maybe I hope to learn from you as well. But I do think, I mean, of course, it's self-serving, but I think it's a good partnership. It's a good pairing, not only because I am very much interested in your issues, and I hope very supportive. But as the introduction suggested, I do have this background as a lobbyist, so I know many of you in the room are interested in advocacy issues, and I hope I can speak to some of those. So, what are we going to talk about tonight in our time together? So, I thought I'd start with maybe a naive question, but a lot of my teaching is about naive questions that turn out to be really good questions. So this particular one is, why is the Constitution important? So we'll cover that issue and think about some of the different ways in which the Constitution might be important generally, but more specifically to the issues and concerns that you all have. And then it's appropriate, the Constitution, to sort of paraphrase John Green from The Fault in the Stars. The Constitution is not a wish granting factory, right? So we should be aware of its limits, both to kind of focus our energies on what it can do, where it's relevant for thinking about, our role as lobbyists, as civic advocates, and the other work that you're doing, but also to appreciate where it's curtailed, where its reach does not extend. And then kind of again a naive but important question, what is it? So we'll do a little bit of in terms of the literacy question. How should we regard the Constitution? Uh, what are its different kind of facets that are relevant to your work and to a broader understanding? And then we'll kind of wrap up, and I'll make some general remarks before we go into Q&A. So again, very basic question: why is the Constitution important? And I think for most of us, our instinct is it's important because it does serve as this kind of blueprint, right? It sets out these different branches of government, and in particular, the branch of the federal government. It sets out a series of commands about our relationship to these institutions. As amended, the Constitution tells us about some of our rights and liberties, but very much in the minds of the people who wrote the Constitution, it was about protecting us by crafting the right kinds of organizations, right? The framers didn't even give us a Bill of Rights initially; had to be convinced and lobbied to include them. So originally, they were very much of the mind that our liberty, our interest would be protected by the right kind of balancing and measuring of government powers. So that's obviously essential. We just to cite one example, we get that from Article 1, and which discusses the powers of Congress, and Article 1, Section 8 is really a laundry list of the powers of Congress. When I was a lobbyist in DC, when I was an advocate for issues in DC, we spent some time thinking about Article 1 and the different jobs of Congress. For reasons we can talk about if you want to, Congress is a little bit less salient, maybe even relevant in 2026, but it's still the people's house, the people's branch, and an enormously influential branch for thinking about federal policy making, and so on down the line. I won't take you through all of the 7 articles and 27 amendments. So we don't have the time or the interest, perhaps, although there's nothing that would make me happier. But you get the idea. This is a kind of again, a list of institutions and powers, a blueprint about suggesting the kind of bones of these organizations. But by extension, it is also then a charter for us to think about responsibilities. A great political theorist said it's a kind of job description, the Constitution, and not just a warning about what government can do to us, but of course a set of instructions as to what roles and responsibilities, especially national government, has. The separation of powers is not something specifically delimited or identified as such in the Constitution. But of course, the Constitution does include not just specific allocations of authority to the legislative, executive, and judicial branches, but a more complicated and messy scheme of each branch being empowered to interfere with each other's work in a way that's supposed to be not just protective, but actually add value. I think we often lose sight of those positive aspects of the separation of powers that when it works well, we anticipate each branch will bring something to the table, perhaps a preoccupation with rights in the form of the courts, perhaps a focus on deliberation and representation for Congress, and of course, a well-known capacity for energy secrecy, unity, and dispatch, as the Federalist Papers puts it, in the form of the executive branch. So the Constitution is important because it is a roadmap of power and responsibility, and again, a set of job listings for us to heed as citizens, advocates, as people interested in policy. Not going in kind of a different direction, and maybe not surprising, but awfully important. I think the Constitution is also important, remains awfully relevant in 2026. We can talk about headline issues, of course. Those will bring the issue to the fore as well. But we are in a low trust environment, right? A number of scholars, including some colleagues and friends of mine, Mark Hetherington from University of North Carolina, have documented a steady tumbling of trust in not just institutions of government, but a wide range of organizations, from small business to the police to banks. There's been a tumbling of trust since the 1960s. And in that environment, it is useful to have a touchstone, to have a reference point, to have a set of structures that are still relatively popular, right? So public opinion polling on the Constitution suggests partisans of both sides still find a lot to admire. There's, of course, interest and talk about reforming the Constitution. Perhaps there's conversation about a new constitutional convention, but relative to a Congress that sometimes dwells in the 9 to 10% range for people who have a great deal of trust, the Constitution is a relatively popular instrument. And don't take my word for it. Here's some of the results from a Montpelier poll saying that 9 out of 10 Americans say the Constitution is important to them personally and protects their rights. We should caution that those numbers are bracketed by a lot of misgiving in we the people about the status of those rights and their security. But that doesn't diminish the importance of the instrument. To some degree, it only brings it to the fore even more. So I submit that's kind of exhibit 2 or point 2, that the Constitution is still relatively popular even in this age of mistrust. There's some great books on this. If you want a little beach reading, two political scientists, John Hibbing and Elizabeth Thies Morris, have argued that while Americans, and they do focus groups and polling to support this, while Americans have a great deal of suspicion and even hatred for what they identify as a kind of Washington system of lobbyists and insiders, and in the eyes of much of the public, sort of corrupted officials, they still have considerable affection for a more abstract constitutional system. And there's a problem there because, of course, one gives rise to the other. But to the extent that you can kind of tap into that, I think we have a powerful node and a powerful, again, touchstone for our conversations and our advocacy efforts. I see this in my classroom. I can often sort of trick my students into having civil and slightly less partisan debates because we're talking about constitutional issues, which are, of course, often about the most heated political issues of the day. But you can take a step back if you engage in constitutional language in many cases, if you use the structures of a Supreme Court case, and it has a kind of civilizing effect on the classroom. So another, maybe third, and just as important point about the Constitution's importance is maybe the most obvious one, but it still bears stating clearly and bluntly. The Constitution, it's perhaps our most insecure of political documents. The Constitution declares itself to be the supreme law of the land, right? So whatever else it says, it reminds us that its commands are subordinate to no others, that a state decision, a state law, a governor's order, even a president's command it should fall in the face of the supreme law of the land. There is no higher. So that is obviously an incredibly powerful arrow in the quiver. If you can identify a constitutional right or provision that is in tension with a state law, you can challenge it. And the Supreme Court has liked this idea so much that they in the 19th century invented this power, not explicit in the Constitution, but they waved their judicial wand about and said, not implausibly, that since the job of the court is to interpret law, and since the Constitution is supreme law, gee, it must be our job to interpret the law of the Constitution. So we can have a chat about the challenges to that point of view. But as a practical matter, in 2026, the court is a powerful policymaker, in part because it has taken upon itself this authority to interpret our supreme law. So just to give you one more concrete example, some of you may know this case, but Miller versus Alabama involves a couple of different juveniles, 14-year-olds. In one case, a young man, Contrell Jackson, from Arkansas, was accompanied two of his friends to a movie store. One of his friends had Contrell discovered that this friend had a shotgun hidden in his jacket. The friend actually did a subsequent killing as part of the robbery, but because Contrell was present as part of an aggravated felony, he was charged with a capital offense. They ultimately did not try to pursue him for the death penalty, but he was sentenced under an Arkansas law which required him to serve life in prison with no possibility of parole. Supreme Court took a look at this in the 2000s. The facts happened in 1999, but by 2012, the Supreme Court lobbied and advocated effectively by this person whom you may recognize as part of the Equal Justice Initiative, Brian Stevenson. The Supreme Court ruled that no possibility of parole, no individual assessment, no chance to kind of weigh the idiosyncrasies of the case was against the cruel and unusual punishment clause of the Eighth Amendment. So with that one decision, the court struck down the life without parole statutes in 29 states, at least as they applied to juveniles, to individuals under the age of 18. So you can see the Constitution's important on its own terms, but it's important in this very direct, very raw policy-making respect, as we've just seen. All right, so just to kind of summarize that first part of the chat, right? That's the case I'm making to you. There's other reasons to think about the Constitution, to regard it, to study it, to make an important part of our constitutional literacy. But for our purposes, for thinking about advocacy, I think these are three crucial features, and we should keep them in mind throughout our work and thinking about kind of how we deploy the Constitution. Constitutional limits. So having told you about the kind of musculature of the Constitution, what are some of the ways in which the tremendous and long arm of the federal law, the long arm of the Constitution, is clipped or blunted or only extends too far? Again, you can't kind of know one without the other. No, we have limited resources, limited energies. We have to be smart about where to deploy our talents, and knowing authority, knowing what is granted, and knowing what is not is, I think, equally important to that task. So maybe the best way to kind of get our heads around this is to read the language of the Constitution itself. The Constitution, again, perhaps in another moment of insecurity, reminds us in the 10th Amendment that its powers are not infinite, right? This is a little convoluted, but the basic gist is something you're familiar with, which is unless a power is delegated, enumerated, set out with more or less specificity in the Constitution, it is if it's unless it's set out, unless it's enumerated, unless it's delegated to the national government, the power is left over to the states or the people. So again, in practical effect, what does that mean? It means that yes, the Constitution creates a federal government of enumerated and limited powers. Congress shall have the power to lay and collect taxes. That's clearly a power of Congress's. But of course, that then limits national power, limits what the Constitution can do. If it's not within those that basket of authority, it's not something the federal national government can do. A famous case, a relatively famous case that looks at this, considered whether Congress, our federal lawmaking body, could pass a law, in 1990 it tried to, that restricted the use of guns in a school. The Gun-Free School Zones Act of 1990 said a person cannot bring a gun within 1,000 feet of a school. Now, whatever you think of the wisdom of that provision, I tend to think it's not a bad idea to make schools about education and not about firearms, but that's beside the point. The Supreme Court said, we're not in the business of deciding whether this is a useful policy or not. We're in the business of saying there is no authority under the Constitution to impose this law. Congress is sort of, in the court's view, Congress's somewhat slapdash efforts were to say, well, we think that keeping guns out of school is important for interstate commerce, and that clearly is a power within the federal government. That clearly is a power in Article 1. But the court said, you just haven't convinced us. This is really about commerce. We think you're trying to enter into the business of criminal law, and you don't have a general license to do that. It's a constitution of enumerated powers. Then Chief Justice Rehnquist begins his opinion by saying just that. Article 1, it's a constitution of limited enumerated powers. I don't see this gun regulation thing in there. We can talk more about that case if it interests you, but the important point is that there's a flip side to this, which is the concession, the backdrop that, in fact, the states are the workhorses, right? And you know this from your own work, you know this from your own experiences. The overwhelming majority of family law matters, of questions about divorce, about inheritance, about criminal law, about property regulation. All those issues are dominated, at least numerically and to some degree substantively, by the states. Just to give you one taste of that, in any given year, there's about 100 million criminal cases litigated in the nation, and about 99.5% of those occur in the state judiciary. So this is a reminder that when we think about our energies and where to kind of pool our resources, of course, national courts matter. Of course, the Constitution is critical. Of course, it gets a tremendous amount of our attention. But a lot of the day-to-day work is in state legislatures. And I guess I think the last, maybe the penultimate point I'll make in this regard is just to observe that another limit, but a kind of double-sided limit, is that these rights are not self-enforcing. Sometimes my students are surprised that there isn't a kind of roving commission that will make sure our civil liberties, our First Amendment, our Fourth Amendment protections against unreasonable searches and seizures are actively protected. There are people who take an oath to make those protections, but lawsuits depend upon our rights and the kind of checks on government power, for the most part, in 2026, depend upon litigation, right? Depend upon parties finding the right plaintiffs to bring action. It takes the bravery and the organization of a group like Stevenson's Equal Justice Initiative to bring these rights to bear. There's lots of powerful and famous examples. An example from yesteryear that we should not forget is Clarence Earl Gideon, with I think the equivalent of an eighth grade education. He's accused of breaking into a pool hall and stealing what amounts to $5 in cash, and taking some bottles of beer. He's charged, and he says, "I didn't do it, and I would like to have legal representation. I can't afford an attorney on my own. I'd like the court to provide me with one." And he was declined. They said, tough luck. State law says you can only do it you only get representation for capital offenses. Other than that, you have to provide it on your own. Well, Mr. Clarence Earl Gideon didn't take no for an answer, so he did his best to educate himself. Here's his handwritten petition that he sent to the Supreme Court that ultimately reviewed his case and sort of made him the exception that proves the rule, that it's generally a good idea to have an attorney represent you, but if you can't have that, try to get Clarence Earl Gideon to do it for you. In any event, cases like his kind of echo this, I think, powerful observation of Judge Learned Hand from a New York appellate court that, we often kind of beguile ourselves when we focus too much just on judges and justices and even kind of law litigated in the courtroom. The law, at the end of the day, will only be as good, right, as we the people make it. And there's plenty of instances, historical, plenty of areas of the law where the facts on the ground determine the shape of the law as much as anything else. We tend to think of a case like Brown v. Board, which where a unanimous court interpreting the highest law of the land said, gee, you must integrate public schools. We tend to think of that case as kind of settling the issue, but of course it did nothing of the sort. And rather grimly, 10 years after Brown has decided something like 3% of Mississippi schools are meaningfully integrated. So, that's its own story of local resistance, of governor shenanigans, and often violent pushback against the law. But the point is to remind us that the Constitution's supremacy, the Constitution's importance, and the Constitution's promise sometimes only go so far in the teeth of resistance and even unpopularity in some circles. All right, so let's try to wrap up so we can have some questions and Q&A, and ask. You can point me to areas I haven't talked about, but again, this is our kind of summary of constitutional limits, right? Some of the ways in which, as you think about the role of the Constitution in your work, you might keep in the back of your mind some of its limits, some of the ways in which it's unlikely or unpromising as a venue for social and other change. So what is the Constitution? This is a huge question. It's one we could spend many semesters on, never mind many hours. But for our purposes, we've partly answered it already, right? What makes the Constitution powerful? What makes it a common reference point is its supremacy. So it's not just a supreme kind of a political charter, but it is, as it declares itself in Article 6, the supreme law of the land. So it's got a legal character. It has and not just any legal character, but this the supreme. It has a supreme cast or quality. Some of the provisions in the Constitution are rather banal or sort of ordinary or clear, relatively straightforward. President must be 35 years old. And of course, some of them are open-ended and requiring lots of work to fill in. There's a legal scholar from Yale, Douglas Ray, who's argued that the word equal in the 14th Amendment has something like 92 different plausible meanings. So obviously, a lot of the work of litigants and of constitutional law occurs in those areas of broadness. In terms of its basic structure, the original Constitution, lays out these major branches of the federal government in Articles 1, 2, and 3. Article 4 deals a little bit with state relations. This is where you get that promise that a New Jersey license will be recognized in California or Mississippi. The Article 5 deals with the amendment process, which maybe we can talk about in Q&A, but it turns out to be a very, very difficult law to change, the supreme law of the Constitution. Article 6 we've discussed, and Article 7 is how the Constitution gets ratified. And with respect to the amendments, we have 27. The 27th Amendment is marginally controversial. I only bring it up because it was discovered by a student, an undergraduate student at one of my alma maters, the University of Texas. But in any event, we really focus a lot of our attention in a couple of areas: the Bill of Rights, the first 10 amendments to the Constitution. That is, of course, where our civil liberties, our basic protections from government come from. For the most part, there's lots of statutes that identify those protections. There's other areas of the Constitution that give us rights, but when most people think about core civil liberties, they're really talking about these first 10 amendments: free speech, freedom of the press, protections against protections for the accused in the context of criminal proceedings, and basic due process or fundamental fairness claims. Happy to go back to any of those. Every constitutional law professor's dream is to talk endlessly about civil liberties. But for our purposes, it's good to just kind of put it into context and recognize that crucial role for, again, a lot of your work. The Reconstruction Amendments after the Civil War, they famously promised to abolish slavery, promised to guarantee newly freed slaves the equal protection of the laws, and promise on paper that the right to vote shall not be infringed on the basis of race. Our complicated and often ugly history from this period or from the period following it suggests that those paper promises were often subverted through ingenious, and I think it's fair to say, devilish schemes. And of course, there's lots of other structural and important amendments, but I did want to note the rather essential extension of suffrage rights to more than half the population with the 19th Amendment. So, constitutional amendments have facilitated sweeping social and political change, and certainly the Reconstruction Amendments, the 19th, and others are powerful case studies in that regard. So all of that is something of a pushback against the observations about the Constitution's limitations. Although, as I've gestured, it's a tricky story, right? The meaningful equal protection of the law really does not mean a lot until the 1960s when Congress passes the Civil Rights Act. Okay. One last kind of point before we wrap up is I think it's fair to say that we often focus rightly on the Constitution as a legal document. It declares itself supreme law. It gives a set of commands. It is often litigated. But we should not forget that it's also a political charter. What do I mean by that? So, and this is an old idea going back to Aristotle, that a constitution is not just a legal charter, it's not just a set of commands written on paper, but it's supposed to be a set of ideals. It's supposed to be a vision of how to live well that captures, embodies, directs, and reflects a people. And it's as Aristotle puts it here, it's the way of life of a citizen body, of a particular political community. And I think that's an important element of this for us to keep in mind as well. Don't take my word for it. The Constitution itself references this idea, I think, in the preamble, right? What are our purported values? What is it that we're supposed to be embracing? And what are the tenets, right? That really comprise us as a people and keep us unified over the years. And I think the preamble, as much as any part of the Constitution, is supposed to give a lot of voice to this. We could look to also the Declaration, perhaps, but that's of course not in the Constitution. The reason Lincoln references makes his fourscore remarks in the Gettysburg Address is because he's delicately leapfrogging over the Constitution to grab up the Declaration and its original promise of equality, equal rights for every person. So the Constitution is political not just in the sense that it has these key values, but that they're really values in conflict. So I probably shouldn't swear on the line, but the difficult personality, the difficult human, Felix Frankfurter, was also a brilliant jurist, a troubling person in lots of ways. He did not treat his clerks very well, but Frankfurter made this profound observation that part of what makes the Constitution so difficult and so compelling is that it is this clash of rights, right? Not just of a clear right and a wrong. And to that degree, to the degree that the Constitution is reflecting our divisions over liberty, security, order, and equality, it is a debate that's not only baked into our supreme law, but of course baked into our body politic. And we see that today. So let me end with, and we've kind of done a lightning tour of the Constitution, hopefully some things for you to think about, hopefully some observations relevant to your work. But I want to end by thinking about, how should we what should we make of this document and its tricky aspirations? And what I want to end with is maybe a part of the preamble that gets overlooked by a lot of us, but is arguably the most important part of the preamble and something that we need to wrestle with in 2026. And that's its promise to not only establish justice, ensure domestic tranquility, provide for the common defense, give us these blessings of liberty for today, which was, originally 1787, but for our posterity, right? For our children, for our grandchildren, for their grandchildren. The Constitution, written on glorified parchment, has this conceit, this kind of outrageous claim that it's going to not only bind we the people of 1787 and their generation, but the next and the next and the next, all the way to 2026 and who knows how much longer. And incredibly, it has done that, right? It has, to different degrees of success, we have accepted this as our supreme law for 238 years. But what I really want to end with is is the suggestion that that's something of a fragile proposition, right? And requires a lot of work. So I think I can best illustrate this by taking a step back and thinking about going in a maybe surprising direction, which is to think about mythology. So you probably are familiar with the sirens, right? These mythical creatures, sometimes described as half women, half birds. They lure men to their deaths, the foolish Greek sailors who get too close with their enchanting songs. They have a bewitching music, right? You've heard of the siren song or the danger of the siren lure. So the sirens appear in a few different myths, but the one I want us to end with is the story of the Argonauts, right? Jason of the Argonauts gathers up his golden fleece, takes a series of sailors on his ship, the Argos, so they're cleverly enough named the Argonauts. And in one of his adventures, maybe his most perilous, I don't know, doesn't check the maps, or I don't know what the problem is, but he sails too close to the island of the Sirens and runs the risk that they will all be devoured by these creatures, bewitched by their enchanting songs, and then meeting the fate of being you can see on the bottom left of joining the pile of bones. So what happens? They survive. And how do they survive? They survive because, fortunately enough, they have a demigod, a half god, half human on the ship, on the Argos. And this particular demigod is named Orpheus. He is the great musician. Orpheus famously could bring animals and rocks to tears. He enchanted Hades with his beautiful song, so that Hades released his beloved. Go see the Broadway show. But in the Tale of the Sirens, what saves the sailors, what saves Jason, what saves them all, is not that they suddenly steer away, not that they defeat these creatures in combat, but that Orpheus picks up his lyre and begins to sing. And he sings so beautifully. He sings so captivatingly. He sings with just the right notes that the sailors turn away from the sirens. The sirens are drowned out. And his example, his counterpoint, his lyrics are more beautiful. And I end with that because I think that's part of our mission, right? If the Constitution is to endure, if it's going to bind the next generation of lawmakers, citizens, many of whom are deeply embedded in this trough of institutional skepticism, they too will have to be, if not charmed, at least see the appeal of the Constitution. And maybe we decide at the end it's time for a reboot. But to the extent that we want to keep our supreme law supreme, it will require not just the work of the courts, but this harder work, arguably, of making the experiment in ordered liberty something that is attractive, something that works for a wide class of people. And with that, I'll bring my remarks to an end, and I look forward to a chat with you all.
This is great, Bruce. Thank you so much. This is I'm such um a history buff, and I'm very appreciative of what you're sharing. It's really taken me back to school and being reminded of what I learned, and certainly wanting to look up a little bit more so I can just be reminded of some of these key points. And just really, what I appreciate is, the highlighting and highlighting to us the importance of the Constitution. Of course, we know it is important, but then just taking us sort of through through that timeline is super helpful, and just reminding us that it is in fact a blueprint for how we live, a vision of, I think you said, vision of how we live, and reflecting the values of we the people, and also reflecting the visions of order and equality. You talked a little bit about that. My question to you is, early on in the presentation, you talked about how um, that there was lobbying that was required for the Bill of Rights. And when you started to talk about due process, freedom of speech, the right to bear arms, and all of that, I'm like, okay, maybe that's answering my question. But, why was there? I guess the question is, why was there, the lobbying effort for the Bill of Rights? Can you maybe just explain a little bit about that and expand on that?
Of course, of course. So yeah, so I mean, you could make the wider case that the Constitutional Convention writ large was a series of lobbying efforts, right? That there were conflicting interests from with respect to state power, with respect to the extent of power that the federal government should have with respect to, of course, whether we should have chattel slavery or not, the rights of different citizens, and also on the question of rights. So the central divide was between folks like Alexander Hamilton, who said, "We don't want to have rights in the Constitution." There are a few. You can't have bills of attainder. You can't have specific law. The body of the Constitution says you can't target individuals essentially in your criminal law, and there's a few others. But Hamilton said the best protection for the liberties of citizens is to get the right kinds of lawmakers in place and to really focus our attention on a structure of government that will prevent tyrants and the concentration of power. And if you instead provide a list of rights, the perverse effect, Hamilton said, was you will limit your imagination to what's listed, and people will be denied other rights that aren't in there. Madison and others countered and ultimately won the day, in part because they needed the votes of the skeptics. And Madison said, you need a document to be educative. You need a reference point for we the people to read and learn about their rights, and then to use them for litigation. And he said, we'll also concede the point by including the Ninth Amendment, right? And the Ninth Amendment says that other rights not enumerated in the Constitution are not denied. That there are other protections that aren't set out in the Bill of Rights. But Hamilton, whether he clearly lost the battle in the sense that the framers of the Constitution promised the Bill of Rights and delivered on that promise in 1791. But he might have won the wider intellectual point in the sense that most people regard the Ninth Amendment as the kind of, last gasp of the unimaginative. When you're really in trouble with your arguments about a civil liberty, you turn to the Ninth Amendment, and more generally, the litigation, the Supreme Court reports that involve constitutional law are all about the first 8 amendments to the Constitution. So he was right? This is our Bible. This is our touchstone for civil liberties. But that's the kind of backdrop that you referenced, Victoria.
Great. Anyone else? I know Cheryl had dropped some questions in the chat. You wanted to mention those, Cheryl, or if there's someone else that'd like to ask a question?
So I'll pick up on one of Cheryl's, which is just
Okay.
what is the proper role
You're
of,
on mute.
oh, sorry.
No, you're
You got
fine.
me? What is the
Go ahead.
proper role of compromise in constitutional advocacy? I mean, that's a great question, right? So part of the problem of putting too much hope on courts when it comes to the constitutional law is it tends to be a zero-sum game, right? It's Randa versus Arizona, Roe versus Wade, DC versus Heller. You have two litigants at loggerheads, and whatever else happens, we tend to think one will win and one will lose. So that's a challenge. Sometimes the court will try to bake a kind of compromise cake. But I think maybe the better answer to Cheryl's great question is to say we do know generally from research that what makes people, and this isn't quite about compromise, but I think it's related, what makes people feel better about losing, right? I mean, the power of the court is kind of miraculous that you're going to lose in a courtroom and still abide by that loss. So with constitutional cases and others, what the work of Tom Tyler suggests is we put a lot of stock in procedural justice, right? If we think that the proceedings were fair, that we had a chance to have our voice expressed, that we are treated well by the judge, by the bailiff, even by the person who waves the wand over us as we do security check-in, we're more likely to be satisfied with outcomes that we don't personally like, that don't seem to serve our self-interests. So that's not exactly compromise, but it is a sense that we're kind of all in it together, which I think is part of the spirit of compromise.
Okay. Great. Well, I have a question about the 19th Amendment, and certainly the Junior League has played, a pivotal role in the women's suffrage movement, in, uh, in wanting and promoting and fighting for women's rights, the women's right to vote. And so the Junior League led in that suffrage movement, and there have been many other organizations as well. The NAACP participated in that. So if you could just share a bit about, just speaking in the context of women leading in that regard, and just to ensure that very, that right for women to have that ability to have a voice.
Yeah, so I mean, the 19th is obviously important with respect to mass democracy, right? It's a funny country that excludes more than half of its population from small R Republican rule, from representative rule. But I think part of what you might be gesturing to, Victoria, is just this, broader point of being accepted as the body politic, right? And being welcome to be a part of we the people and our debates about what that justice in the First Amendment in the preamble, pardon me, really looks like. It's it's one of the reasons why I'm not an originalist, right? There are people who think that you should interpret the Constitution based on the public meaning, how the words were understood in 1787, 1791, whatever the year is of the provision. Part of the reason, there's several reasons I resist that, but one reason I resist that is because in many cases, those words were written at a time when huge swaths of the country were not included, were not referenced. If we the people if we should think of we the people in kind of a more perfect union sense, it should be generally at its most inclusive, right? So the 19th is a uh, partial, important and partial resetting of that framework and an expansion of not just rights, but of who the body politic truly is.
Great. Anything else? Any other questions, Cheryl or Ariel, that you have? Or anything in the chat? I know,
I'm
Cheryl,
looking at the chat right now. Where does the Constitution meaningfully limit advocacy, and where is it silent? Such a great question. So, well, it powerfully invites advocacy in the First Amendment, right? I mean, this is not my idea, but it's an idea I love. One of the ways to look at the First Amendment is it is a kind of life cycle of an idea, right? You've got the right to free speech. Where do you develop that free speech? For many, where do you develop your ideas about speech? Where do you develop the ideas that you want to share? For many people, it's through faith. So we've got our free exercise protected. Well, then, how do you disseminate your ideas? Well, with a free press. And then at the end, what do you do with your idea, which may have a constituency? You've got your right to assemble and petition the government for redress of grievances, right? So right there in the First Amendment is this invitation to advocacy. In terms of its limits, I mean, the limits probably aren't, for the most part, explicit in the Constitution, but they have become explicit through our laws and through our case law, that is the Supreme Court readings of the Constitution. I'm not giving you a very good answer to that, but I think our history has been one of relatively robust protection for political advocacy. It gets a little messier in recent decades when that advocacy has been treated as when sort of communicative lobbying and advocacy is being uh, what's the word, conflated with payment, right? With dollars. So we have a number of decisions that have said it's a problem to restrict the expenditure of funds as speech. So, depending on your point of view, um, an individual's advocacy might be washed out a little bit if they have to compete with a corporation's unlimited funds. So that's a kind of byproduct of a case and of case law rather than an explicit command of the Constitution. I don't know if that helps, Cheryl, but that's part of the way I approach that. Great
Does. Thank
question.
you. Thanks.
Yeah. I mean, we could do a whole seminar on your questions. They're all great, but let's see. Anything else I can address? I hope this was useful.
This was great. Bruce, thank you so much. This was great information, a powerful presentation. I appreciate the time, and it was very thorough. So thank you so very much. And thank you for, being here.
My pleasure.
I'll
Okay.
echo that. So thank you so much. Thank you.
Okay. Well, I think we will end here and thank you. And I'll just ask Cheryl and Ariel to stay on and invite you to enjoy the rest of your evening, Bruce. Thank you so very much again.
Appreciate your time. Thanks a lot.